Good afternoon. I'm Jane Trudeau. I'm on the Cary Memorial Library Foundation Plain Giving Committee. And on behalf of the foundation and the Mariah Hastings Cary Legacy Society, I'd like to welcome you to our program, which is being televised by LexMedia and will be available for home view if you'd like to do it again. They say do everything twice. The Cary Memorial Library Foundation is the primary fundraising organization for the library. The foundation created the Mariah Hastings Cary Legacy Society to honor those who included the library in their will. Legacy gifts are important. They're a wonderful way to share your good fortune, and they ensure that the library's wonderful collection, quality, variety will be available for future generations. And it can also save estate taxes. Our topic today is estate planning basics, which focuses on the importance of estate planning. You know, there's a saying, where there's a will, there are relatives. Well, there are also relatives even if you don't have a will. And so one of the things I'll be talking about is the importance of estate planning. It maximizes your control over how and when your assets are distributed. It allows you to make financial decisions when you're well and able. It diffuses potential conflicts over assets. It can minimize estate taxes, and it helps ensure that affairs are covered if you're incapacitated. Very fortunately, as we were preparing for this program, I received the following letter from Jonas Clark the 14th. And he says, my 50th birthday party was ruined because my family spent most of the day reminding me that my spouse and I don't have wills or durable powers of attorney or healthcare proxies. You have a copy of this in your file. So I want to get together with you and the other members of our estate planning team to take care of the situation. It shouldn't take too much time, nor should it cost too much. I've listed assets, but we're not going to dwell on his assets other than answering general questions. I listed them so that you would have some idea when we talk about an estate, what's included in a taxable estate. And some of these items are a surprise to people. So as you can see, I am not rich, but I want to be sure that my family is taken care of. My wife should be all set because she's the beneficiary of the life insurance policies on my life. I do help to support her mother though, and I want to be sure she lives comfortably. I give her $2,000 to $3,000 a year. The cash from this comes from my father's estate. I didn't inherit anything from him except the right to a point where the $3,000 a year goes. When I die, I can give that right to anybody I like. And right now I'm undecided. There is my mother-in-law, my disabled son to consider. In addition, upon the death of both my wife and I, we would like to make a gift to Cary Library. Finally, all my friends tell me I should avoid probate. And I'd probably do it if I could figure out what happens when you avoid probate. Is it good or bad? Last of all, how much will figuring all this out cost me? Not much, I hope. Could we get together Sunday afternoon to chat about it? Where should Jonas begin? Well, there are attorneys who discuss your family needs and assets, and then they create the documents, wills, trusts, powers of attorney, healthcare proxies, both to provide for your family and minimize taxes. Accountants focus on income and estate taxes. A trust officer can advise you as to the use of trusts in the management and investment of assets. And finally, financial planners provide an overview of your estate planning and current and future financial needs, in addition to providing investment advice and management. And we'll be beginning our panelists right now. We have, very fortunate, we have not one but three lawyers. Patrick McAvoy, Rebecca O'Brien, and Kevin Sargis, who's also a CPA. And on this side, we have a trust officer from Cambridge Trust, Edward Fitzgerald, and two financial planners, Peter Hoffman and Brianne Spiro. And what I wanted to say is, at the end, we'll have ample time for questions. So if you'll hold your questions and let our panelists speak, afterwards we'll have plenty of time for your questions. So my first question is to Patrick McAvoy. Patrick, what will a will do for Jonas?
Hi, Patrick McAvoy. What will a will do for Jonas? I think this is best explained by first introducing you all to what probate is, because probate is where wills come into play and where wills are important. Probate in Massachusetts is essentially a legal system for the transfer of property at death. Importantly, probate only applies to property that you haven't otherwise provided for by joint ownership, by the use of trusts, and by beneficiary designations. That is, probate generally only applies, and wills only apply to property that you've left just in your name. It doesn't control property that you have a joint owner for. It doesn't control IRAs and 401ks, which you have beneficiary designations for. And it doesn't control property that you put in a trust before you pass away. Property that does go to probate ends up following two sets of rules, one of two sets of rules. There's a set of rules in probate for people who leave wills that controls where that property goes, and then there's a set of rules for people who don't, for the property of people who do not leave wills. People who leave wills are referred to as testate, and people who don't leave wills are referred to as intestate. Generally, what happens is if you die and leave a will, the court applies its rules in such a way as to ensure that your property passes to the people you've named or entities you've named in the will. If you die and you don't leave a will, the court rules apply, and the court ensures that your property passes pretty much to your closest living relative. Generally it goes spouse, children, grandchildren, great-grandchildren, and if there are none of those, then back up to parents, siblings, nieces, nephews, cousins, and so on until very far away in some cases. The probate process it starts out very simply, and it can be very simple in Massachusetts. Essentially what you do is if someone passes away, their closest relative or somebody who's in charge or someone named in a will as a PR or personal representative or executor files paperwork with the will, files paperwork with the court, essentially telling the court who has died, who their closest relatives are, whether they left a will, and who the people named in the will are. You file that paperwork along with a death certificate and a will, if any. You notify all the closest living relatives and the people named in the wills, and then the court passes on basically the validity of the will, and it names someone called a personal representative. A personal representative in Massachusetts used to be referred to as an executor or administrator. We, for some reason in 2012, changed the nomenclature. It's now a personal representative. The personal representative takes over, essentially takes the place of the decedent, manages whatever affairs there are to manage, pays bills, pays taxes, and then oversees the property to make sure either it passes according to the terms of the will or it gets to the closest living relatives of the person who's passed away. Turning now to our client Jonas, I guess the main question is whether Jonas needs a will. The answer to that in almost every case, and I would suggest in every case, is yes. And the reason everyone should have a will is not that they intend to use it and they intend to go to probate. Now, I believe in probate avoidance, but I also believe that a lot of times when we try to avoid probate using joint ownership, beneficiary designation, and trusts, things go wrong. So people you intended to benefit by joint ownership can predecease you. Trusts are invalid. There's property out there sometimes that people don't know about. Property and abandoned property, spin-off company stock. And so you don't really know that you don't need a will ahead of time, so I would suggest in all cases that you execute a will leaving your property somewhere. And then if you plan to avoid probate anyway, that's fine. You set up your joint ownership, set up your trusts, do your beneficiary designations, but you definitely want a will. Also, if you look at Jonas's case study and letter, you'll notice a few things that actually require a will. First, Jonas has a disabled adult son. I said that probate is essentially or mostly a system for the transfer of property at death. Probate also has other functions, and one of those functions is the appointment of guardians for minor children and adult disabled people. So, and a will is a good instrument for doing such an appointment. There are other instruments for that kind of appointment, but in Massachusetts, I think it's most commonly done by will, and that's usually the most effective place, and that's where we have kind of a system set up. So Jonas needs a will to take care of his adult son. Jonas also has something interesting. He has what's called a power of appointment, which is the power to dispose of property that was in his father's estate. That's a very common item in the estates of wealthier people. And in this case, Jonas has to exercise that power by will, so he needs to have a will to tell us where the property in his father's estates go. So not only does Jonas need a will just because everyone needs a will, but he has some specific items that come into play and require a will in his case. So in closing, I would just say that that's essentially probate in Massachusetts. I think we've covered it. You should avoid it if you can, but you should make sure that you have a will just in case your plans for joint ownership or trust ownership don't come together the way you planned. And with that, I'll turn things over to Rebecca O'Brien, who's going to discuss small business.
As Patrick mentioned, there are many ways an estate plan could benefit Jonas. I'm here to talk about some specific considerations with respect to Jonas's shares in SFB Incorporated. That's Small Family Business Incorporated. To begin with, the most basic level, Jonas should think about how those shares are going to be distributed to his heirs in his will. We know he has a wife, and we know he has a son, and he has a mother-in-law. We don't know to what extent any of those heirs of his might be involved in the day-to-day running of the business. If his wife, for example, is involved in the day-to-day running of the business, he may wish to give all of his SFB shares to her and the other assets to his other heirs. Or if he wants to set aside some for his mother-in-law and then make the estate roughly equal between his wife and his son, he may wish to give them equal shares of SFB because he might not know how much the company will be worth at the time of his death, so it may make sense to divide equally between the wife and the son, and then arrange for the wife to buy out the son's shares after his death so that they would get equal shares of the assets in the estate, and his wife would retain control of his 1/3 share in SFB. Another issue is that whoever Jonas appoints in his will as his personal representative, so as Patrick mentioned, the personal representative is the person who helps distribute the assets of the estate according to the will. Whoever that is, Jonas needs to make sure that person has access to Jonas's small business accounts, his bank account, and then also his email accounts and social networking accounts. First of all, this will help the personal representative distribute the assets of his estate most effectively. And also, you can imagine the many problems that could occur if no one has access to those accounts, and emails go unanswered, bills might go unpaid. So it would make a lot of sense for Jonas to keep a document with his small business account information and passwords, login information in a document that he can easily update, and for him to make sure that his personal representative has access to that document as well. Now let's talk about power of attorney documents. A power of attorney document is something where you write a document giving someone else power over your affairs if you should become incapacitated. Now, most people have one power of attorney document. Maybe they create one that says if they become incapacitated, they would like someone, most often their spouse, to take care of their affairs for the time that they're incapacitated. I want to mention that for someone who has a small business, it might make sense for them to have more than one durable power of attorney. A power of attorney can be written to be limited in scope. So someone like Jonas could appoint his wife, perhaps, to have control of his personal affairs, his personal accounts, and his assets, personal assets, if he should become incapacitated. But then, if she's not involved in the business, he might want to appoint someone else, like a business associate or a business partner, to take care of his small business affairs, should he become incapacitated. So someone like Jonas might want to consider having more than one, perhaps two, durable power of attorney documents written. As with the will, whomever Jonas is going to appoint to take care of his small business assets if he becomes incapacitated should also have access to his small business accounts, like I mentioned earlier with the personal representative. An entirely different kind of document Jonas and his business partners should really consider is what's called a buy-sell agreement. That's a binding legal contract among the owners of a company agreeing what will happen to a partner's shares when the partner dies or retires or becomes incapacitated. So in the case of Jonas, if he were to die, he has 1/3 of the shares in the company. What happens to those shares when he dies? Would the other partners buy those shares from Jonas's heirs? Or would the heirs take over the shares and perhaps help run the business? Do his partners want that? Or could the heirs take the shares and sell them to a third party? And if they want to do that, do the other partners get input as to who will have those shares at that point? All of this can be ironed out in a buy-sell agreement that would really help the company down the road. And another important provision that a buy-sell agreement could have is provisions about how the shares of the small business will be valued. So often with a small business, it's unclear how much a share like Jonas's 1/3 share is worth. How much is that worth? So if the partners can agree ahead of time how the shares will be valued, that would really help, so that if the surviving partners are buying shares from the deceased partner's family, the family knows they're getting a good price, a fair price, and the partners know that they're paying a fair price. Jonas should also consider creating something called a succession plan. You've probably heard of this at some point. He owns 1/3 of the company. Maybe that he has a significant role there. And if so, it would make sense for him to set out create a document that sets out his vision for the company. Once he is gone, who will take his place? And if that person is not available, who would the alternate successor be? And when Jonas leaves, what will the structure of the company look like? Will there be personnel changes? To the extent Jonas can set this out ahead of time in a document, it would help the company down the road. Another issue for Jonas, and the final one I will talk about today, is insurance. If Jonas and his partners have a buy-sell agreement, whereby the other partners will buy the shares of a partner who has died, it may make sense for Jonas and his partners all to take out life insurance policies listing each other as beneficiaries. If they don't do that, when someone dies, the other partners may not have sufficient funds to buy out the shares of the deceased partner, so they wouldn't be able to carry out the provisions of their buy-sell agreement. So it may well make sense for them to get that kind of insurance. And then also, Jonas should consider taking out a policy with his family as beneficiaries, so that when he dies and they no longer have the stream of income from SFB, they will have the funds from the life insurance policy to help with that.
And up next, we'll ask Kevin Sargis, what's included in a taxable estate?
Thank you, Jane. My name is Kevin Sargis. I'm a tax attorney here in Lexington, and I have the scintillating task of describing taxable estate. So, when one passes away, the personal representative is tasked with gathering up and organizing and compiling all of the assets of the estate, both for probate reasons and non-probate reasons. One's taxable estate actually combines both of them. You may succeed in avoiding probate, but that doesn't necessarily mean that you've avoided the taxability from the state tax perspective on those. So you may set something up and say a joint account, but if that joint account is something that you created, you control, you use, that's an asset that's going to be included in the taxable estate. So basically, anything that you can touch, own, control, if you own real estate, that's in the taxable estate. If you own an IRA, that's in your taxable estate. Life insurance, interestingly, so unless you do some planning with life insurance, the proceeds of life insurance, if you have a $500,000 policy and you die, $500,000 is treated as a taxable asset in your estate. So the personal representative gathers up these assets and compiles them, and then decides for both federal purposes and state purposes whether there's a filing requirement. So for federal purposes, and this is changing as we speak, and in 60 days you can just delete this, because this may not be applicable. But at the moment, roughly $5.5 million is exempt from federal estate tax. And if you're married, you can multiply that by 2. So if you had $11 million, you won't owe any federal estate tax. That's one sort of common understanding of this. The second is if you're married, both the IRS, or the federal treasury, and the Massachusetts have something called the marital deduction, which basically means when the first spouse dies, there's no check to be written, assuming that your testamentary expression is to your spouse. I mean, if you give it, not to a charity like Cary's Library, but if you give it to, say, your children, well, that doesn't qualify for the marital deduction. But if you, when I draft documents, I call them I love you documents. If you give everything to your spouse, then those qualify for marital deduction. So you maybe technically have a taxable estate, let's say it's $7 million, but you decide to give that to your spouse, well, you're not going to have to write a check when the first spouse dies. The federal estate structure works extremely easily in that the surviving spouse has something called a portability election. So again, this is all for somebody that has $11 million or less. First spouse dies, that spouse has $5.5 million of exemption to use. If that spouse doesn't use that exemption, the surviving spouse can check a box and say, I'll use whatever he or she didn't use. So for federal purposes, a married couple can avoid estate tax on $11 million. There may be a filing requirement, especially if you want to check that box and use the portability election. But basically, for $11 million and less, nobody's writing a check ever. And again, maybe in the next 60 days, that may be nothing. So we'll just have to wait and see. More specifically, Massachusetts has a $1 million exemption. So if you have $1 million or more, you have a Massachusetts estate tax filing responsibility, and you likely may owe Massachusetts estate tax. Same thing applies with regard to the spousal marital deduction. If your testamentary expression says, I give everything to my spouse, then Massachusetts will also wait. They won't expect a check after the first spouse dies, but after the second spouse dies, if you have assets more than $1 million, you're going to need to write a check to Massachusetts. And the way Massachusetts works is you're either a taxable estate or you're not. If you're less than $1 million, you don't even have to file a return. Although strategically, sometimes if your estate is close to $1 million and there's maybe valuation issues, you might want to consider filing a return just to start the statute of limitations. For example, if you had an estate of $950,000 and you had questionable valuation on your real estate, what is your real estate worth? Well, you might want to file a return that shows you have $950,000, don't pay a tax, and see if that is accepted. If you have more than $1 million, then you have to file a mass estate tax return. Again, if you have a spouse, that spouse can claim the marital deduction and push the writing the check off till later. The way Massachusetts does it is if you have a taxable estate, you're actually taxed on the first dollar. And it starts at 3.8%. And ultimately goes up to 16%. The federal rate at the moment is 40%. There are ways of reducing your estate tax. The most common way is just with gifting. You can gift up to $14,000 per year per person. It's a very common strategy. And if you do that, it's as if nothing's happened. You just have reduced your estate. You don't have to file any forms. You don't have to tell anybody. $14,000 per person per year. Massachusetts doesn't have a gift tax, but it does enjoy the benefit if you reduce your estate, then you're helping reduce your mass estate tax. That is estate taxes 101, very high level. Again, it's changing. Certainly the federal is changing. In my practice, what I've seen is that there's frankly very fewer people that are subject to the federal estate tax, but the Massachusetts estate tax, it's $1 million, and $1 million is a lot of money, but that is a threshold and it's not really changing. It used to be about a dozen years ago, Massachusetts, believe it or not, was no different than Florida. For a brief period of time, Massachusetts technically didn't even have any estate taxes. They had something called a sponge tax, which is what Florida has. And as the federal exemption kept going up, $675 and $750 and $1 million and $1,050,000 and $1.5 million, Massachusetts started to get less checks in the door. And so they did what was called decoupling. And so they disconnected their system from the federal, and their threshold now is $1 million. And I don't think there's anything in the works that I've heard of that's changing. So if you have more than $1 million, you have to at least think about do some planning for mass estate taxes. Okay?
Ed's going to tell us about trusts.
Trusts, first, one thing I just want to add on to what Kevin said about the gifting, and so it may be obvious, but may not be obvious to everyone, is that if you're a married couple, that gifting is $14,000 per person you can give. So for example, if you have a grandchild, you and you're a married couple, you can each give $14,000 to that child for a total of $28,000. And the second thing related to that, and it doesn't have to do with trust, but it's something that comes up in discussions very often with clients, is that when you, it's important from what Kevin was saying to avoid paying taxes on the money that you have if you don't need to. And one of the ways is gifting. You know, he was talking about gifting, and of course, whether it's to the library or to an individual, making a gift, it's only tracked as a gift if it goes directly to the individual. If for example, I were to pay, and I don't have any grandchildren yet, so this is a fictitious grandchild, but if I were to pay $10,000 towards my grandchild's tuition bill directly to the University of Massachusetts, that's not considered legally a gift. I'm simply paying the University of Massachusetts $10,000. So the whole gifting thing is really why you should be talking to a professional to help you manage this process and make sure that you keep track of everything. So trusts. What is a trust? We've talked, a couple of folks have already discussed it a little bit. What I want to just emphasize about a trust is that just as we heard very early from our first presenter about how important it is to have a will, the very first things, I work at Cambridge Trust, one of the very first things that we talk about clients about is, do you have a will? Do you have a power of attorney set up? Do you have healthcare proxies? Those are all very important things. Everyone doesn't need to have a trust, and that's something that I want to emphasize. But the fact is that what a trust does is it does create a set of instructions that can go beyond the instructions that you put into a will. And I'll give you an example of why that might be important. But first, I want to just describe, there's two different kinds of trusts. One is a revocable trust, and just like it's, even though it's pronounced revocable, think of it as revocable, meaning you can change it. As long as you're living, you can change it. You can make whatever changes you want to, as long as you'd like to. An irrevocable trust is the opposite. Once it's done, it's done. There are some technical clauses and things that can be changed, but in essence, you're setting up something that is permanent and can't be undone. Some people set up irrevocable trusts for the purposes of holding insurance policies and the benefits and dividends and so forth from those insurance policies, and therefore removing them from the normal asset class. So that is a reason why someone might set up a trust. Like you name a personal representative, formerly executor in a will, you name a trustee for your trust. And that trustee very often is going to be someone that, no pun intended, you trust, but it's truly important that that person understand all the financial implications of a trust, that they understand taxes, that they understand a variety of things about you personally, and therefore can act the way that you would act if you were able to follow through with the guidelines that you laid out. So I'll go to the next slide, but I'll explain what I mean by that more. What does a trustee do? The trustee really does what you call fiduciary management. And what that really means is that they'll take care of tax returns for the trust, not tax returns for your family, but tax returns for the trust. And they'll also provide potentially investment expertise, for example. That's something that we do, and that's something that the two gentlemen that will be talking after do. So you want someone as a trustee who can provide investment expertise. Now, a lot of people choose a family member as a trustee. There's a benefit to that because you have an element of trust. There's also a downside to that because the family member is not disassociated with you. There's a saying or a phrase that's used called a disinterested trustee. And very often, you might want to have a family member as a trustee, but have a disinterested trustee, meaning that it's an attorney or a bank, someone who is acting independently and doesn't allow emotions and determined expectations to affect anything. And I'll give you an example of that. One of the things that you might set up in a trust is that maybe you've got 3 children, and 2 of the children are very careful with their finances, and 1 isn't. And so one of the things that you can do with a trust is to lay out exactly how funds will be distributed, and that by having a disinterested trustee, you're not having your nephew, your son, your daughter, your brother-in-law or sister-in-law being the person who has to say, no, you can't have that $30,000 to buy that boat. You've got someone who's independent and who's off to the side, but is in control of doing what you have laid out ahead of time. So that's just some thoughts on choosing a trustee. What does a professional trustee look at? There's a whole host of things. I'm not going to go through each and every one of these, but if you see them, they're in your packet. And basically, a professional trustee will look at all aspects of your personal situation to make sure that all of the financial aspects are covered, that whatever you've set up in the trust is followed through with. Sometimes I'll talk about a client situation that I'm working very actively with right now, without naming names, of course. We have a person who, the decedent, had a substantial amount of money, and the nun has no children living, but has grandchildren living. The children predeceased the person. So what they did is they had set up a trust, and the trust allows all of the income from the trust to be passed through to those grandchildren, but the value of that trust is not directly passed through. So that's something that can be done through a trust. And if you think about that, that has the benefit of, A, there's no taxes, like when Kevin was talking about, taxes from, passing from one generation to another, and, what the inheritance taxes and so forth are. If the assets remain in a trust and someone just gets the benefit from it, all that they're getting is that income, and so all they get taxed on is the income. They don't get taxed on the full amount of the trust. So that's a benefit of it. And that's really what the next slide talks about, is it's a way that you can minimize the tax disadvantages of dying. It doesn't minimize the disadvantages of dying. You're gone. But you can minimize some of the tax situations from that. So, and one of the things Kevin mentioned was a married couple can pass $2 million to children by passing some of that money through a trust, setting up a trust for their surviving spouse, and having that done ahead of time. You can't do any of these things after someone is no longer here. It has to be done while people are clear thinking. It has to be done while everyone has all their faculties and they can sit and discuss with an attorney what it is that they really want to have. How is it that they really want to have their assets laid out? And so they really need to sit down with an attorney with the specialties like we have on this side of the panel, to really make sure that you're doing what you want to do, and that you are creating, in some cases, gifting into the irrevocable trust during your lifetime. As I have on the slide, insurance, I mentioned that earlier. It's also a place that you can put other money, and that money can, again, provide income to people in the future, but not be taxed other than that. This right here is just a quick summary of what you can do to minimize estate taxes. It's not federal. There's probably a handful of people in this room that might be worried about the federal taxes, but there's a lot of people who are worried about the Massachusetts taxes, because once you have a house, if you have a house and something else, it's very easy to get to $1 million. It's not very many people have $1 million in their hand, but they do have assets of $1 million. So it's very important that you think about it and that you look at whether it's of benefit to you to set up a trust. A will is essential, no matter what. Like I said, everyone needs a will, not everyone needs a trust. But the more complex your assets are, and the more complex your family situation is, and especially if there's differences in the children or grandchildren and how they may want to be treated, trusts can be a way to do that. So what I'll do at this point is just pass it on to Peter Hoffman. Peter's going to talk about IRAs, which are basically a way for you to save money while you're working and then collect money later on in life. Peter?
Thank you. So, how many people here have IRAs? Okay, almost everyone. How many people here have received or are the beneficiary of an IRA? So you have an inherited IRA. Okay, a number of you. So we're going to talk about both sides of this, using an IRA as a vehicle when you're going to be passing on funds, and also some things to think about if you're on the receiving end of it. Now, if you're on the giving end of it, you have to think about what the receivers are going to be thinking about also. So this is going to get you on both sides. So let's talk about some do's and don'ts, and then we're going to get into some specifics here. So the first thing is that an IRA is not independent of the rest of your estate plan. So you really always want to be asking the question, what is it that I'm trying to achieve? And make sure that what the IRA is doing makes sense in the context of your overall estate planning. Now, one of the places this comes up is the whole idea of a Roth conversion. And why might you do a Roth conversion? Well, it turns out that if you, let's say, are going to be leaving money to someone whose income is higher than yours, you may have a child who's a doctor or a lawyer and they're making a lot of money, it may cost them more when they're taking money out of the IRA because their income is higher, they're going to pay a higher rate of taxes than you might. And so it may make more sense from an overall point of view for you to do a conversion and pay taxes now at your lower income tax rate so that when they inherit the money, they don't have to pay taxes. So there's a multi-generational aspect to planning around IRAs, and a Roth conversion is one of the tools you can use there. Now, another thing you can do that some folks don't know about is a qualified charitable distribution, a QCD, which is a way to make a charitable contribution directly out of your IRA. Now, if you're taking money out of your IRA now, you're over 70 and a half, and so you're taking distributions, you know that that money is coming in as income to you, and you have to pay taxes on it. But you can direct that money, that minimum required distribution, or if you want to give more, you can always give more, but you can send that directly to a charity, and then it won't count as income for you. And if you do that, then if you're in a situation where your income is pushing you up into having to pay more for Medicare, you might be able to avoid that by using this QCD, or qualified charitable distribution, coming out of your IRA. And they only can do that once you're 70 and a half. So if you're not at that point where you're having to take money out, it doesn't work. And then there's also the opportunity to make a payment or contribution to an HSA, or health savings account. Now this is only for those of you who are not yet of Medicare age and are still eligible to contribute to HSAs. If you're in that category, you have a one-time opportunity in your life where you can make a direct contribution to your health savings account out of your IRA. And the reason you might want to do that is that you'll never pay taxes on the money coming out of the health savings account if you use it for appropriate health purposes. So the money, when it came out of the IRA, if you took it out normally, you have to pay income tax. But if you put it into an HSA, then you don't pay income tax on that, and you'll never pay tax on the money coming out of the HSA, and it can grow there in the meantime. So let's talk a bit about the whole idea of beneficiary designations, because this is so important when we talk about IRAs. What you put in the IRA for the beneficiary designation overrides all other estate planning. So it doesn't matter what you have in your will. The IRA has its own orders, and those are built into the IRA. The beneficiary information you put in there overrides everything else. So you want to make sure you really get that right. Now, sometimes you'll move your account from one place to another, and as part of that account opening process, you have to go and designate beneficiaries again. You don't want to drop that out because you're in the middle of signing all these papers. Very important to do that. Now, if you're going to be getting an IRA, if you're inheriting an IRA, then it's really important that the way that IRA is named when it's created for you as an inherited IRA is named properly. Because if it isn't, it won't be an inherited IRA, and you won't get the benefit of the stretch or being able to take out money over the course of your lifetime. So each custodian, whether you're at Fidelity or Schwab, wherever you are, they'll have their own rules about what that naming is, but it needs to include the name of the person who is deceased, and typically the date that they're deceased, and it has to say beneficiary. So it could be John Doe, deceased 12/10/2010, for the FBO, for the benefit of Mary Smith, beneficiary. You know, something like that. That makes it an inherited IRA and makes those specific rules applicable. Now, you also have the opportunity to make a trust the beneficiary. It doesn't have to be a person. And if you do this, you really have to do this carefully. Why would you do this? Well, for some of those same reasons we were just talking about for trusts. You can be protecting the money from being spent. Let's say if someone is a spendthrift, or someone is too young, or they're someone that can't be trusted with a large sum of money, by putting the money into a trust, the IRA money going into a trust, that trustee can manage the distribution. And that also gives you asset protection if you set it up correctly. Now, we won't get deeply into this, but there are two kinds of trusts, and some trusts just pass through all the money onto the beneficiaries, and others can actually accumulate the funds in the trust. So you really want to work with a good estate planning attorney when you set up your trust documents to make sure that you're getting what you want to have happen, because there are a lot of different things that could happen, and you want to make sure you get it right. If you're giving money to multiple people through your IRA, and they each want to stretch out their withdrawing of the money by their lifetime, you actually have to end up with separate accounts for each person. If you leave it in one account, then they're going to take it out over the lifetime of the oldest person. So if you leave it to a child, and your child is 50, and they have a child that's 10, and you leave it half to the parent and half to the grandchild, if they don't split that account into two accounts, then the money's going to have to come out of that account based on the age of the 50-year-old. And you don't get the growth that the 10-year-old would have had for their half over their lifetime. So, very important, use an estate attorney who's familiar with this. There's also something called a trustee IRA. We were just hearing about what a trustee is and how a trustee can be useful to manage accounts. There are actually IRAs now that can be managed in a trustee manner, so that if you don't have someone who you think can manage the investments, and you're concerned that you don't have someone who would be a good steward in your family that's going to be giving out money, you can actually have the entire IRA handled by a trust organization. And they'll both handle the distributions and the investments. You only want to do this if you have a very large IRA, because it's not cheap, And the money, once it's there, may never be able to be transferred to another place. You have to really like that organization. But for the right people, that's a new option that's worth knowing about. So, a few other points. Estate taxes can be due from the state, and the people who are inheriting the money may in fact have to use that money to pay the estate taxes. And if that's true, then they may be having to take a lot of money out of an IRA that they just inherited, and because it's all income to them, that to pay income tax on that, and then goes back to paying the estate tax. That's the kind of situation where if the parent had done a Roth conversion in advance, it might have made a lot more sense. Now, if a spouse gets an IRA, they can just roll it into their own IRA. They don't treat it as an inherited IRA. They don't have to start taking money out. They can just have it there until they're 70 and a half. But it's the same thing as if it's their own IRA. But if you're not a spouse, then you have all these different rules. You have to have it named properly. You have to take minimum required withdrawals or distributions. They're called MRDs or RMDs, but it's money you have to take out every year starting the year after death. And you won't get a penalty if you're under 59 and a half, but you do have to start taking out money. And there's a special formula that you use about how much you have to take out every year. It's based on how old you are when the person died, and then it gets incremented by a year every year after that. But again, you have to have a separate account from someone who's older than you, or you're going to be stuck with their rules. And let's see. Oh yeah, if you're giving money to a charity or some organization, you want to make sure, and you're also giving it to other people. Okay, so one of the beneficiaries is your church, and the other beneficiaries are your children. You have to make sure that the church gets their money paid out in the year after you die. Obviously, if you're the one dying, you're not going to be doing this, but you want to set up and want to make sure this happens, because otherwise the other beneficiaries won't get the possibility of stretching out, taking their withdrawals over the course of their lifetime. So you always have to separate out institutional money from individual money, and even for the individuals, you want to make sure that they have their own accounts so everyone gets the maximum stretch. And last point here, when those accounts are set up, again, this is different from other IRAs. You can't just take the money out of one IRA, the one you're inheriting, and say, oh, I've got this 60-day rollover and I'll take the check, and then no, I'll open a new account in 60 days. Doesn't work. That will count as all being withdrawn and will be taxed. You have to do a trustee to trustee transfer. So it has to go from wherever that IRA was before to wherever you're going to have your IRA without you ever having your hands on the money. So, and I think we can move on here to Brand.
It's on the podium, man.
Good afternoon. What I'm going to try to do briefly here is step back and take a look at how all of this stuff kind of comes together. You've heard a little bit about financial plans and also about estate plans, and actually a good financial plan can help direct your estate plan, and I'd like to kind of explain how that could work. In a good financial plan, you decide what your goals are, whether it's to travel, possibly educate your grandchildren, pay for their college, whatever it is. And you decide, here's what my big goal is. And then you take a look at your financial situation. So for example, you look at your total assets, your liabilities. But one of the things that's most important in a financial plan is to look at issues related to your longevity. there are going to be people in this room that are going to live past 100. So you might want to see how your funds will hold up over an extended period of time. And so that's very important. Another aspect of a good financial plan is dealing with family issues. In Jonas, in the case study we had, there was a special needs issue. But potentially there's issues with your children or your grandchildren, and you want to set something aside for that, and you want to talk about what is the financial implications of that. A lot of people here know people in nursing homes who have home health care aides, and when I talk to most people, they're continuously surprised at the cost. It's higher than they expect. So one of the things you also want to do is figure out what might be the anticipated health care cost for you and your family. Another issue is retirement plans. Peter discussed that. I'd like to extend that not just to IRAs, but to 401ks. Some of you might have been working at a place, let's say 30 years ago, and you set aside a beneficiary, and it's still there, it's sitting at that company, and the beneficiary was your ex-spouse. And that might not be the person that you want. No matter what your will says, that money is going to your ex-spouse, even if that is not your desire, and I bet it isn't. So those are some of the things you kind of sort through, and then I'd like to talk about gifting during your lifetime. Now, people come up and ask me, well, what do you think I can afford to gift? And I don't know how you could possibly answer that until you do some type of analysis and some type of plan to figure out various things. One of the ways that I think a good way to look at how much you can afford to gift and a sort of a methodology to go through is like you're on an airplane. Do you know how at the beginning of the flight they say, attention, if we have run into problems and you need your air mask to come in, first put it on yourself and then attend to your children. Well, I look at planning as well as estate planning as you first figure out what do you need to do to take care of yourself, and you will be in a better, consistent position to take care of other people and other organizations that are most important to you. Looks like the slides won't. Okay, and actually go on to the next slide. So after you've done the analysis and you figure out, all right, this is what I need for the rest of my life, here's some assets, here's my goals, here's family issues. And one of the reasons you're here today, of course, is to gather more information. And I'd like to share with you a recent story I had with my 100-year-old financial planning client. And we're discussing things, and she started complaining to me. She said, you know, this would have been much better if I were in a little better health. This is hard to do all these things. It would have been much better if I handled this when I was 99 or 100. And I said, yeah, I think that's probably true. And one of the things that you see as you go about this is you're always going to say, I think I need to get more information. I think tax laws are changing. Our financial situation is changing. Something else is changing, and I really don't want to think about my own mortality anyway. So you keep on putting things off. So one of the things I recommend is, if you haven't obviously done a estate plan or a financial plan, do it. But even for those of you that have, and many of you have, at least revisit it. Take a look. Has anything changed? Particularly if you already know things have changed or are unsettling for you. So the point here is that it's great to gather information, and I think it's very important, but at some point you say, okay, here's my deadline, now we're going to move forward. Next one, please. I'd like to quickly give a word for our sponsor, Cary Library, from today. I know many people in this group, I'm a board member of the foundation, have generously given to the library, and we do want to thank you. Also wanted to touch upon, quite briefly, a few other vehicles that you might want to consider in making future donations. You obviously could have the beneficiary in your will or trust, life insurance, IRA, and donor advisory funds. And I'd like to briefly, and go into the next slide for that, I'd like to briefly explain some things about the donor advisory funds, because what I've seen in the donations coming to the library is more and more people in the Lexington area are using these funds. So I briefly wanted to touch base on what they are, and also a couple of things to be concerned about as you do your planning. Okay, so what a donor advisory fund is you make a donation to one of these funds, and at Schwab, Vanguard, Fidelity, lots of places offer them. And what it is you can donate cash or most likely appreciated stock to the fund, and then you have an account there. So let me give a quick example. You have a stock that is currently valued at $10,000, but when you purchased it, it was valued $2,000. You could sell the stock and take an $8,000 capital gain, or you can donate that appreciated security to a donor advisory fund. You get the $10,000 tax deduction, plus you no longer pay capital gains. Now that is a donation to the fund, and now you can't take the money back, but now you have a $10,000 pool of money that you can designate to charities at that time. And another benefit of these donor advisory funds is, let's say you did this in 2017, you get the tax deduction in 2017, but you can decide in 2017, 18, 19, whatever time you want, you decide which charities and when you distribute it. So you have the flexibility if you say, oh, I got the stock, I want to sell it, I want to donate it, but I can't figure out when and exact amount. You have the flexibility of donating it at a later date. By the way, you can't get a second tax deduction when you distribute it. It's the one-time tax deduction. Then when you distribute it to someplace like Cary Library, you wouldn't get an additional donation. It's only when you donated the initial stock. I would like to tell you one thing I've seen that's a problem that you want to make sure you do if you set up a donor advisory fund, and I know some people in this room already have them. One of the things they have on the bottom, and it's similar to what Peter talked about when it dealt with IRA designation, is they ask for successor advisors to the fund. So let's say you and your spouse donate the money, and you fill it out. You're the person responsible for the finances, and you're doing it, and then you put your spouse as the successor advisor. You pass away, or if your spouse passes away first, regardless, there's no other advisor after you on your list. Where do you think the money goes? To your charity of choice? No. Where it goes is it goes back to like in Fidelity's case, it goes back to the Fidelity Charitable Gift Foundation, and that company decides where it's distributed. You say, well, that's not what I want. So you quickly have your child's lawyer call up, and guess what happens? They say, I'm sorry, if you look at the terms of the donation, that is outside of your control. It's outside of your family control. I don't care who calls us. It's not coming back to your family. So I would suggest you'll probably put one advisor on it, but I've already seen this as a problem. I would put several advisors down. And therefore, it stays in your family, and when you made the donation, the reason you probably did it was so that your family could support the charities of choice. And finally, I know this is a great Sunday afternoon. Obviously, you guys are interested because there's many other things you could do. We'd like to thank you for attending today, and I'd like to again emphasize the point, do all the research you need, talk to all the people you need, but at some point, set a deadline and take some action. Thank you.
Before we take questions, and I would hope that everybody gets to do their first question before anybody has a second question, I'd like to thank our panel. They've donated their time on a very nice Sunday afternoon to help the library, and I hope that some of your misconceptions or understanding has been improved. So are there any questions? And you can either ask specific panel members, or you can ask a general question and they'll decide who answers it.
I have a microphone.
You have a mic.
Yeah, you talked about IRAs specifically, but there are other similar vehicles like 401ks, which were mentioned, or self-employed 401ks or Roth IRAs. Are the rules that you described the same substantially for those, or are they different?
Yes, the mic over there.
So,
Well,
Grant,
Rand has
you-
it. Thought we had two.
Thanks. The answer is yes and no. So, some things are the same, so the general principles are the same, but when you get into the specifics of it, there are actually some differences. So, here's an example. If you have IRA, you get an inherited IRA, okay, you were the beneficiary of an IRA. That IRA, by a recent court ruling, is not considered to be protected. It's not looked at as your retirement asset. It's just an asset. So if you're sued, that money actually could be lost. Whereas money that is in a 401k has ERISA protection and is not subject to legal claims in the same way. So, so there are some differences, but in terms of the importance of naming beneficiaries, that's definitely the case. Okay, so, and then they can cross over. If you take money out of the 401k, you can put it into an IRA, so the rules can change as you go through those shifts. So the general ideas of the growth of usually untaxed money is the same, but what happens, the rules around taking it out are potentially different. The rules of each 401k will govern those distributions, and those are different from the rules for IRAs. So yes and no.
Yes?
One second.
My question is about coordination of all the different aspects. And by this I mean you have financial planners, you have estate advisors, you have legal and many things. And if you go to one expert in each field, you really end up perhaps not doing yourself a favor, because things may not be well coordinated and balanced. So my question would be, is there such a thing as one-shop place in which this coordination takes place?
I suspect the answer depends on the complexity of your estate. Ed?
Yeah, I'll talk to that just a little bit. I would like to do a commercial now. No. The fact is that when we talk to clients, we talk about building a team of people. So is there an independent person that you can go to try to pull together? And that's honestly what I recommend. What I recommend is that chances are you've got one person, whether it's your attorney that you've been working with on, your will and so forth, or whether you've got a CPA that you've been working with for many, many years and you feel very comfortable with them. Whoever you have, what you should do is use them as a resource to build that rest of that team to make sure that people are on the same page. Acting in our role, like, being the trust officer, obviously we deal with trusts, but the fact is that we try to pull together a team for people who don't necessarily have a team. We'll, assemble a team of an attorney, a CPA, a financial advisor, whatever it is that you need. And the other side of it is that there's two different things when we're talking about trusts before, the IRA actually. It was talking about this custodial, and there's two different things you can do with your money, and one is that you can have it being managed by an independent financial advisor, for example, sitting right here. That advisor can really perform two different functions. They can be a coordinator, sort of the quarterback and basically identify, okay, we're going to put it here, 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 and here. And they can also be the person that's actually investing it also. So depending on how comfortable you are with your investments, you may want someone that's just going to carry out your desires, or you may want someone who's going to really coordinate everything for you. So that will dictate who you choose to help build your team if you don't have a team. But I would suggest starting with someone that you do trust, or someone that you feel that you can trust, and then having that person help you build that team of advisors.
Yes, I have a question about gifting. Is it possible to make a gift to a trust, say to a supplemental needs trust, that $14,000?
Yes. Yes.
Okay.
Yes, you could make gifts to trust as long as you have no interest in it, if it's for someone else. In other words, you can't be gifting to yourself, it's not going to do anything. And if you've set up a trust for either supplemental needs or grandchild, you can certainly use your $14,000 exemption. To some extent, the $14,000 exemption is really only relevant for people who have $500,000, because until you give away that amount, you have no gift tax. So for most middle-class people, and Mass has no gift tax. You know, there was a famous comedian, W.C. Fields, and he was observed leafing through a Bible when he died, and someone said, "Why?" And he said, "Looking for loopholes." Well, if there's a loophole, Massachusetts does not have a gift tax at all. So, and if you're under $1 million, there is no tax. I mean, there's some complexities to that. But the $14,000 is not what it used to be unless you have a federally taxable estate. Then it's very important. But at any rate, Diane?
This is a question about the donor advised funds. I do have one. It's one of my major beneficiaries when I die. Fidelity has this thing that they call successor or terminal beneficiaries, which they have led me to believe mitigates the necessity of a secondary advisor.
Right, so that's a good point. So, but you'll probably, when you look at that form, you'll see one line, and let's say you put your spouse on. And let's say you pass away and your spouse passes away and there's nobody after that. What happens is it doesn't go to your will, it goes to what you would need to do is you'd say, I'd like an addendum, or I'm going to put a couple more people. So it's number 1 successor, number 2, number 3. So yes.
The successors that they talked about were like terminal beneficiaries. So a successor would be Cary, like, you know, it's like I take up my,
if you're giving
my
to-
residual estate and divide it up.
Well, that, okay, good distinction. So here's, I guess, what I was talking about. Let's say you had $100,000 in the fund, and upon you, at the end, you distributed $50,000. But $50,000 you wanted your family to be able to decide where to do it. If you don't designate who in your family has that authority to designate it, the $50,000 that wasn't designated specifically, that would be the money that would go back to them. So it's your entire amount.
I think what she's getting at is that you could name a remainder trust, but charity.
Yes, and then if it's 100%, you're all covered.
No, but if there was 50,000 left, you can say, upon my death, if there's something left, you can say where you want it to go. You can name a beneficiary, essentially. And we've had that, you remember Marge Batten, she did that.
Right.
Excuse me.
I have a question, how to fund trust. And I made a revocable trust, but I don't know the exact value when the beneficiaries or trustees will get exactly until, I don't know how much, until the day I die, then they're gonna know the value of my how much they're gonna get from me. But now, how can they split? Say I give it to two trustees in my trust. How do they make their own separate account, not knowing exact value, what they're gonna get? Until the day I die, they don't know. So how do I fund it? How do I fund it?
There's two aspects to your question. I'm going to address the first part of it, okay? The first part of it is that working with an estate planning attorney, you can establish the trust. The trust does not have to be funded, meaning doesn't have to have money in it. But you create the documents with, using one of the, I'm not one of these three attorneys. You can go somewhere else, honest. No, but, you would work with an estate planning attorney, you prepare the documents, and you just don't fund it now. So it's not critical that you know exactly how much there is, but you know who the trustees will be. And it's usually try to choose a family member you trust and someone who's more disinterested. So you don't have to put the money in now. You can put the money in upon your death as through your will. But
when they're going to make their own, so when they decide to have their own account.
Well, no, it's the trustee the purpose of the trustee is to act on your behalf, not on their behalf. So it should be a very clear distinction between who's the trustee and who's a beneficiary. Beneficiary might be your family members, that you want to benefit from this trust, but the trustees are the people who are held accountable for managing that trust and therefore have to do what you wanted to be done with the money. So they're not there for themselves. They're there simply to implement the rules of the road that you lay out when you prepare those legal documents with the attorney. And maybe one of the attorneys wants to talk about that a little bit. Just explain.
Well, I think essentially a trust is just a set of instructions. And what you're saying, I'm going to keep my money in my name while I'm alive, but then you have a will that says, put it in my trust. It would go through probate on its way. But then you have instructions. Okay, now I want this into two accounts, one for each son. It's your words that control. But at any rate, I hope that helps. Do you have another question? Gloria?
I was wondering if you could say something about how you get a stepped-up basis. Say your spouse owns stock that's now worth $100,000, but it costs $10,000, but you don't owe any estate taxes. How do you guarantee that you have a basis of $100,000 when you die?
It happens automatically, but the catch is you have to die. Everybody who dies, we get a stepped-up basis so that we avoid capital gain. Excuse me. Yeah, in terms of gifting, it's one thing to give away cash, and it's another to give away stock or a house that's appreciated in value. The capital gains tax, for example, is much worse than the mass inheritance tax. People come in and say, I want to give my house to my children. Those children will be back beating me up when they're paying 20% on $700,000 of gain, and whereas if they died owning it, and even if it was over the million, the mass tax sort of averages out at about 10% of the amount above $1 million. You don't give away appreciated property, and you don't even have to file a return to get a stepped-up basis. But the condition is not to be sought after.
I just want to add one thing to your specific question too. If you are alive, and you're not talking about your trust, you're talking about as a living person. If you have stock that's very highly appreciated, in the business we refer to that as low basis stock, meaning that it costs very little, but maybe it's worth a lot now. And sometimes you might inherit stock from a parent, and you might, if it's a company that's been around for 100 years, you might have inherited it when it was worth, $8 a share, and now it's $180 a share. It isn't worth $180 a share until you sell it. So you're not taxed on anything until you're selling it. But what happens sometimes is, if you want to make a donation, as we talked about earlier, that can be a very effective way of making a donation, because that's not money that you actually have in your hand. You have the stock certificate. So you can take that stock certificate and donate it. And when you donate it, you're donating it at full value to the charitable organization. And so that's a way of creating tax cuts for yourself while you're still earning money. So that's just something that's not exactly what you were asking, but I wanted to mention that because I think it's important.
Anyone else? In the back?
So we've gone through the financial plan, gone through the estate plan that's set up for Massachusetts and the US, and everything's great, done the due diligence. And then you move to another state, or shock of all shocks, another country, you're gonna have to redo the whole thing, right? Right? In other words, you've done, you've got the ideas down, but you're still gonna have to go see somebody else and that.
I can, just to quickly address that, what I recommend for most of our clients who leave the state and stay in the United States at least, is that they just visit with an estate planning attorney in the other state, have that estate planning go over their existing documents and make sure they'd be sufficient. Because the states vary a little bit as to wills and trusts and what's required to form a valid trust and what's required for a valid will, but to a large extent they're the same. And so you probably, if you stay in the States, don't need a complete rewrite. The countries, I mean, you do the same thing, obviously. You'd have to go visit with somebody in the country
But it
and
can
make sure there are.
act as a template for what.
Yeah, I mean, it'll give you an idea of what your intentions are at least, and they can translate it into what's needed in that country. But it may also, I mean, in most states, it's going to work out most of the time that the documents are still valid, and in most of the countries, they could probably use it as a template. Yes.
Thank you.
Over here. Yeah.
So I just want you to clarify that how do you avoid, if I want to give my house to my kids, how to have them avoid the capital gain tax? You just said. Okay. If I just have will, that's not enough, right?
The basic rule for this capital gains tax avoidance is that one who inherits appreciated property gets a stepped-up basis. So if you bought your house for $10,000 and it's worth $100,000 now, if and you give it to your children and then they sell it, that's a gift during your lifetime. They would have to pay tax on $90,000 in gain. If instead they inherit it from you when you die, they can go and sell it the next day and not pay any tax on anything.
So
there are different ways to convey it to the children upon your death. I mean, there's a myriad of ways. You can have a deed that reserves a life estate to you. You can put it in a revocable trust now, or you can leave it by will, and those will all get your children the stepped-up basis. It's just you have to retain enough interest in it that it would be taxable in your estate if you had a taxable
What
estate.
I really want to know, do I need a trust? If I just have a will, say inside the will, I leave
If you leave it to them by will, they will get a stepped-up basis, yes.
Okay. Thank you.
Paul?
So this is about beneficiaries. You talked about beneficiaries for IRAs. Let's assume I've specified the beneficiaries for my IRA, say to be a marital trust. Is there any reason why I wouldn't have my non-IRA accounts in my house? Is there any downside to specifying a marital trust for those also?
Generally, I prefer that. I mean, just as a estate planning matter, we usually try to avoid naming a trust directly as the beneficiary of an IRA. We prefer houses and bank accounts and things like that are great assets for marital or other trust situation, but trusts are somewhat disadvantaged as beneficiaries of IRAs. It's better and I have to generalize a little bit here, because I don't know all the situation and what kind of money is going around or whatever, but generally, you'd want to appoint your spouse directly and then have your spouse appointed to children or charities or wherever someone go, because the spouse has that great, it was mentioned that a spouse can roll over an IRA when you appoint them as beneficiary, and that's a big advantage, especially if your spouse is much younger. But it's a big advantage because then the spouse can then go and name more beneficiaries, and they can appoint it directly, usually to children, and then the children can take over the IRA over their lifetime. So we tried, there are some cases where we'll put, or make an IRA, or a trust the beneficiary of an IRA, but generally we try to avoid that.
Yeah, is there on an IRA conversion, is there an age limit or something, or do you have to be working? I mean, if I'm over 70 and a half and I have an IRA that's not a Roth, can I still convert it?
Peter?
You can't, yes. But again, what you would do, let's see, let me, she's in charge.
Yes, you convert it. What you would do, so it's an option for you. Systematically, what you want to do is you'll take a look at what's the tax consequences, because it could be substantial, because let's say in your IRA, it's $100,000. If you had gotten tax deduction on everything you contributed into your IRA, you have an ordinary income tax, if you do the whole thing that year, of $100,000. Now, if that's what you want, you've gone over it with your accountant and it makes sense, and also given your family situation, it's good, and it's an option you can do, but the only thing is, I just suggest that you think about the implications of the conversion in terms of the tax consequences, and if it works for you, great. But it definitely, people think, oh, well, I guess it's just a capital gains tax or this and that. No, it's an ordinary income tax, and it can be quite substantial. So I've just seen some people are a little surprised, but you could do it, it's an option.
Just want to add one last thing to what he was saying. And Rand was implying it, but it depends on what your tax bracket is currently, whether the impact of that. Because if your current income is not very high, it will be a lesser degree of impact than if you have a pension and, money that you're already collecting from other things and a business that you're getting money from, then yes, it can be very significant, the tax implication of conversion.
Okay, my question has to do with the clock ticking. When a spouse passes away and there is the desire to sell a home, is there a tax benefit to selling it in a certain period of time?
Well, as to the deceased spouse part, you get a stepped-up basis. And as to the survivor, you have then a $250,000 exemption of gain, but you get a stepped-up basis on that half. To the best of my knowledge, there's no time. That's considered long-term capital gains, even if...
I had been told that you had to have the sale within 2 years of the death of the spouse. Okay, so it can be...
No,
No, okay, good.
all in agreement.
That's great.
All dead. Well, I think, okay.
If I want to add my child to the title to my house, like on the deed, would that create kind of tax event? Is that a taxable event, or is that part of lifetime giving?
So when you put your child on the deed, you are making a taxable gift to that child. Taxable in the sense that it's reportable, but unless you're giving him more than $5.5 million, you don't have to write a check. So it really doesn't do anything from a federal estate tax perspective. There's no mass gift tax, so you can do that. There's really nothing to prevent you from doing that. But you're messing around with your step-up in basis when you do that. So you're gifting half your property to your child and he or she is going to get your existing basis, which may be quite low, so that when he or she goes to sell, it would be better to get a full step up in basis, and then there's no capital gain. People do that, it's comforting, put them on the title, but you do have some tax considerations to weigh there. The other thing, just regard to the Roth conversion, you're paying a tax now, and a tax deferred is a tax avoided. So you have to figure out the time value of the money. You pay your tax now, you have a $100,000 IRA and you convert it, now you have a $70,000 Roth IRA. That $30,000 of tax that you paid, that's gone, and you may be with us for 30 more years, so you have to sort of weigh that time value of money. Roth conversions are there, but they're not really for everybody.
Anyone else?
There's one last question, this lady in front.
Hi. My husband and I have always had the goal of saving enough money so that we can support ourselves during our retirement without burdening our daughter. We recently had a conversation with an attorney who proposed a different goal of maximizing the amount of money that she will inherit if we both die earlier than we expect to. So by putting assets in a trust or something like that. So my question is, are those two goals incompatible? If I put assets in a trust, does it make my life more difficult if I happen to live a long life?
Is it a trust that you still have an interest in, or you're giving it away?
I haven't wrapped my head around it, so I can't answer.
One
And
thing.
if it's a revocable living trust, and
Yes.
it's just a way to avoid probate, there's no downside to you. But if
No,
you,
we already have
somehow
that. It
you're
was something
limiting.
different.
No, it's
Well-
one of the things that you get back to, and because we've thrown a lot of terms today, is irrevocable and revocable, and even though it sounds like more lingo, it's a real important thing in this case. If it's an irrevocable trust, that means that you have no control over it at all. Otherwise, it's not allowed to do that. And therefore, your child really has control over those funds. And the big issue that you have to think about is because you're not only giving control to your child, but possibly your child and your child's spouse. And you have to decide if you feel comfortable relinquishing the control before you might want to. But if it's a revocable trust, then you could just put it in and then you can take it out. So the first thing I would ask is, before I did anything, is could you go over, whoever your attorney is this irrevocable? I have no access to it, I have no control, it's out of my estate, or is it revocable, at which time I have much more control?
And I want to bring up a whole different point of view on this, which is, if you step back and say, my goal is to be able to provide for my daughter if we have premature deaths, then that's the kind of thing that life insurance can be very good for. So before you start doing trusts, you really need to figure out what's the best vehicle where you can get the maximum leverage out of your assets to achieve the goal that you want to achieve. And it may have nothing to do with trusts at all.
Jane Deutsch, who's the chairman of the Plan Giving Committee, will wrap this up, I think. At any rate, thank you all for coming.
I want to thank all of you for coming, and I particularly want to thank again the panel and Jane Trudeau. Jane's been organizing this for many months, coordinating with people, and making it as seamless as possible. And everyone's just done an outstanding job. I've learned a lot. I've heard a lot of terms bandied around that I didn't really understand, so I'm glad I was here. And I just want to thank all of you for all your hard work. We appreciate it. Thank you.